The President, please be seated. The President, today, Monday the 27th of June 2011, the trial chamber of the extraordinary chambers in the courts of Cambodia started the hearing on case number 2 concerning the 4 accused, Boan Nguyen Chia, male born on the 27th of July 1926, to Kieu Sampon, male born on the 27th of July 1931, 3 Ieng Sari, male born on the 24th of October 1952, and Ieng Thirit, female born on the 10th of March 1932. All of whom are charged with crimes against humanity, genocide, through the killing of members of the Chams and the Vietnamese, grave breaches of Geneva Convention of the 12th of August 1949, and violation of the 1956 Cambodian Penal Code, which includes murder, torture, and religious persecution, which have actively and passively been acted through joint criminal enterprise, planning, instigating, ordering, aiding and abetting, committed in Phnom Penh within the territory of Cambodia, and during the period from 1975, the 17th of April, through the 6th of January 1979. The bench is composed of judges, Nel Non, myself, the President, Silver Cartwright, Ya Sakon, Jean-Marc Lavergne, too many, and reserve judges, Yu Otara, Claudia Fens. This initial hearing is held pursuant to Rule 80 bis of the internal rules. In accordance with this rule, and as described in the agenda issued to the parties on the 14th of June 2011, the Chamber shall, at this hearing, consider the lists of potential witnesses, civil parties, and experts submitted by the parties as relevant to the first segments of the trial. It will further consider preliminary objections pursuant to Internal Rule 89 and has allotted time to the civil party lead co-lawyers to provide initial specification of the substance of the reparations averred. They intend to seek pursuant to Internal Rule 23 quinquies 3b. Although the agenda is intended to provide guidance to the parties on the scheduling of the initial hearing, all dates and times are indicative only. These dates and times are subject to change based on progress over the following days on all items for discussion. Before we proceed to the actual hearing as planned, The chamber would like to invite Mrs. Saikolvati to report on the presence of the parties to the proceeding. Mrs. Saikolvati, good morning, Mr. President. Parties who are present and absent include the prosecution is present, the accused are all present, except national co-lawyers are present, and Diana Elisa, the international co-counsel for integrity, is absent. The civil party lawyers are present, 13 people altogether. The President, thank you, Mrs. Saikolvati. Next, we proceed to the recognition of foreign lawyers. Before we start the hearing, the Chamber would like to invite each national lawyer pursuant to Rule 22(2)(a) to proceed with any requests for the recognition of foreign lawyers not previously recognized by the Chamber. We shall now start from Council Saw Sawan team, and we would like to invite him to seek or proceed with a request for recognition of his co-counsel. Council Saw Sawan, good morning, Mr. President, and thank you, Your Honors. I would like to now introduce Counsel Jacques Verges, the international co-lawyer for Mr. Khieu Samphan, the former head of state. The President, thank you, Mr. Saw Sawan. Trial proceedings before this chamber. Pursuant to this recognition, you enjoy the same rights and privileges as a national lawyer. Please be seated, Mr. Saw Sawan. The President, the Chamber has noted the presence of Mr. Pick Ong and Mrs. Elizabeth Simonow, the International Civil Party lead co-lawyers appointed by the ECCC in accordance with the provisions of Rule 12(10) of the rules. Next, we would like to invite Mr. Pick Ong, National Civil Party lead co-lawyer, to request the recognition of the foreign civil party lawyers in attendance in accordance with the provisions of Rule 22(2)(a) of the rules. Mr. Pick Ong mic is not activated, say the interpreter.
Sorry. Some group.
Council Pick Ong, good morning, Mr. President, Your Honors, the co-prosecutors and counsels for the accused and everyone in and outside this courtroom. I am Pick Ong, and I would like to add the civil party co-lawyers. Here we have with us only I am alone as the national co-lawyer. The other national co-lawyers are not available to be here since the seats are limited. They will be attending these proceedings during the break, I think perhaps at 10 o'clock. With regard to the recognition of the international co-lawyers for the civil parties, I am honored to indicate that there are 9 civil party lawyers here present in this courtroom. We have already requested for the recognition of 2 international co-lawyers. And these 9 civil party international co-lawyers are representing 3,850 civil parties altogether. And I have referred to this statistic by the figure released by the court recently. And in light of that, of the court release statement, these counsel have been appointed to represent them fully. And the civil parties have been very grateful to the decision by the pre-trial chamber regarding the civil party applications. Behind me, there are 9 co-lawyers that I would like to really seek recognition from the trial chamber. First, may I seek recognition of Mr. Lima Nguyen. Could you please rise? She is an international co-lawyer from Australia representing foreigners who are Cambodian civil parties living abroad. And they are ethnic Vietnamese. She representing the clients with counsel Sam Sokung from the Legal Aid of Cambodia, or LAC. Number 2, Mr. Olivier Bahuny, international co-lawyer from France. He is representing victims, the charms, and also victims who have been suffered from crimes committed on the religious grounds. And he representing the clients from the counsel from the LAC. I would like to introduce another counsel, Emmanuel Jacomi from France as well. He represents civil parties in France and in Cambodia, and he works with Sam Sokung. Number 4, Miss Philippine Suits. She is an international co-lawyer from France, and she is representing clients with Mr. Emmanuel Jacomi and counsel Sam Sokung. Number 5, Ms. Silke Studzinski, who is present today in this courtroom. She is an international co-lawyer from Germany. She is representing general civil party lawyers, and in particular those clients who suffered from the gender-based violence. And she is from the work with lawyers from LAC and also CDP. Mr. Kaspar O'Boy, the co-counsel from France. He represents clients from France, and he works with his co-colleague, Mr. Hong Kum Soon from CDP. Number 7, Mrs. Martin Jagang. She is an international co-lawyer from France. She is French, and she is representing general clients along with her 2 national colleagues, Mr. Kim Meng Ki and Mrs. Moch Suwanari.
ហើយតំណាងបាទហើយដូចគ្នាដែរគឺលោកស្រីមេធាវី Fabian Trus
Mrs.
ជាមេធាវី
Fabian
នៅក្នុងក្រុម
Trus
ASF ដូចលោកស្រីមេធាវី
also
មកជាកាន់ដូចគ្នាដែរ
representing clients in the same group, and she is from France.
តំណាងកូនក្តីជាមួយលោក
She is representing clients along with councils Moch Suwanari and Kim Meng Ki.
លោកស្រី
Last but not least, council number 9,
ជាមេធាវី
Council Christine
ក្នុង
Martineau,
ក្រុម
French national,
មេធាវីគ្មានព្រំដែន
international co-lawyer from Avoca Song from Chair.
ហើយមានដៃគូដដែលគឺលោក
She represents her clients along with councils Kim Meng Ki and Moch Suwanari.
នេះគឺជាមេធាវីអន្តរជាតិដែលមានវត្តមាននៅពេលនេះហើយ
Your Honors, these are all the civil party co-lawyers who are representing the clients all the time being in this courtroom, and I would like to seek the chamber's recognition so that they can fully represent their clients before the ECCC. I am very grateful, Your Honors. The President, thank you very much, Counsel Pek Ong.
លោកស្រីមេធាវីអន្តរជាតិតំណាងដើមរងរដ្ឋបាលនីចំនួន9រូប
The 9
ដែលមានឈ្មោះដូច
civil party co-lawyers as represented by Counsel Pek Ong and seek recognition by the trial chamber. Now you are recognized by this chamber as the civil party lawyers for the civil parties and for the purpose of the trial proceedings before this chamber. Pursuant to this recognition, you enjoy the same rights and privileges as the national co-lawyers for the civil
ជា
parties.
កិច្ចបន្តអង្គជំរះសូមណែនាំដល់មន្ត្រីរដ្ឋបាលតុលាការដែលបានដែលរៀបចំ
Next, we would like
ដំណើរការសម្រាប់រួលកិច្ចដំណើរការនេះថា
inform
ដើម្បីឲ្យកិច្ចដំណើរការធ្វើនីតិវិធីទាញហេតុផលផ្ទាល់មាត់នាពេលនេះ
court officers
និងនាពេលខាងមុខ
that in order to facilitate the smooth operation or functioning of the proceedings, and in particular with regard to the advanced age of the accused, we
ឲ្យដំណើរការសូមរូតវាំងណូន would like to instruct that the curtain of the courtroom is drawn close when the judges of the bench are proceeding to the deliberation room. And this is a general instruction unless there is a new amendment to this current instruction. ជាកិច្ចបន្តឈានចូលដល់របៀបវរៈការប្រកាសអំពីបញ្ជីឈ្មោះសាក់សីដើមរងរដ្ឋវិនីនិងអ្នកជំនាញបណ្ដោះអាសន្នសម្រាប់ដំណាក់កាលដំបូងនៃការជំនុំជម្រះ
Next we proceed to the other item of agenda concerning the pronouncement of the list of witnesses.
អំពីចេតនារបស់អង្គជំនុំជម្រះ
At the trial management meeting, the chamber advised the parties of its intention to commence the hearing of the substance in the following order. Number 1, the structure of democratic Cambodia. 2, roles of each accused during the period prior to the establishment of democratic Cambodia, including when these roles were assigned.
ការទទួលខុសត្រូវរបស់ពួកគាត់តាមការចាត់តាំង
3. Role of each accused in the democratic Cambodian government, their assigned responsibilities, the extent of their authority and the lines of communication throughout the temporal period with which the ECCC is concerned. And number 4, policies of democratic Cambodia on the issues raised in the indictment. The purpose of this early indication was to give advance notification to the parties regarding the sequence and organization of the trial. The Chamber also advised that it would give advance notice of which witnesses, experts, and civil parties will be called by the Chamber in relation to each segment, so as to allow timely preparation by the parties and witness and expert support unit. To assist the Chamber in its identification of witnesses relevant specifically to these early trial segments, the parties were requested to provide supplementary lists of all witnesses, civil parties and experts sought by the parties in relation to these early segments no later than 20th of June 2010. Based on these supplementary submissions and the parties' earlier witness, civil party and expert lists, the Chamber has since drawn up a tentative list of witnesses, civil parties and experts that it intends to call during the first trial segments. In order to avoid resorting to closed session at this stage, the Chamber has prepared for the parties a written list of witnesses, civil parties and experts tentatively proposed for these early trial segments. This will now be distributed to them. Court official is now invited to distribute the list to parties.
សូមអញ្ជើញលោកសុនអរុន
The President, Mr. Son Arun, you may now proceed. Council Son Arun. I am Son Arun, National Co-Lawyer representing Nuon Chia. First of all, Your Honors, Mr. President of the Trial Chamber, my client is of advanced age and his health is deteriorating. I therefore request Your Honors to allow him wear the hat because he has been affected by the circulation of the air conditioning without wearing that hat, and on top of that we would like to ask that he could wear his sunglasses to protect his eyes from this glaring light in the courtroom. Furthermore, in my capacity as the co-lawyer for Nuti, I already wrote a letter to the CMS so that the desk for Nuon Chia's counsel, who has already been recognized as the full rights counsel as the other council to, of course, we requested that the desk is prepared so that it can accommodate the council comfortably, but it has not been, the request has not been entertained. And as I already indicated, we would ask that we enjoy the same right, equal rights as the other parties to the proceedings, so that we can actually comfortably remain seated when representing our client in this particular courtroom. We already made the request to Mrs. Nisha so that she could actually, the head of the DSS, so that the message can be communicated to the trial chamber or to the CMS, but the response is rather negative. Because they said that this desk can only accommodate, the desk has already been fixed. And I'm afraid that if the status quo remains, we are afraid if the hearing lasts several months, then we will have much difficulties consulting our colleague or client. Thank you. The President, thank you, Mr. Sonaron. Counsel Sonaron continues. My client would like to have a few words before this chamber. I believe that he will be brief if your honors allow. The President, please let the bench solve the issues concerning your request for your client to wear hat and glasses in the courtroom. The chamber finds that it is appropriate that your client can be allowed to wear the hat because he may not be used to the condition in the courtroom. And when it comes to the glasses, of course he will be allowed to wear sunglasses to protect his eyes. Regarding the desk, we have taken note of your request, and we hope the CMS will be well communicated, and we believe that it is not really a very big concern to be addressed, and we are convinced that this will be resolved as soon as possible. And we would like now to hear from Nuon Chia. Nuon Chia. The President, you may speak while remain seated. Nuon Chia. First of all, my sincere respect to Your Honor, the President and the judges of the bench, my fellow Cambodian citizens inside and outside Cambodia. I am not happy with this hearing, and I would like to to allow my co-counsels to actually explain the reasons behind this.
The President, we allowed the accused to briefly speak of what is on his mind.
ចំណែកឯបញ្ហាតទៅ
And that should be briefed.
មិនអនុញ្ញាតទេ
For other
ព្រោះ
matters,
វាក្រៅរបៀបវរៈ
the chamber will not
Đây,
allow
ban thẩm
because
lập.
it's outside the agenda for this particular initial
មេ
hearing.
ធាវីអាចវិញអង្គុយចុះ
You may now
ឲ្យ
be
ជំរះនៅ
seated
បន្តកិច្ច
and we will proceed with our
លោក
proposed
អាចនិយាយបាននៅ
agenda.
ពេលក្រោយ
You
ដំណាក់កាលនេះ
may
គឺមិនទាន់អាច
speak
និយាយបាន
when
ទេ
the time
មិញ
comes.
ថាគាត់ចង់និយាយពេកឥឡូវយើងឲ្យនិយាយរួចហើយ
We just then allow your clients to
មក
briefly
និយាយ
speak
ក្រោយពី
and
ហេតុដែលត្រូវ
besides that you are not allowed to stand and to speak when the time is not
ចុ
yours.
ងក្រោយនៃបញ្ហាដែលមានបើសិនជាមានបំណងគឺនឹង
And for other miscellaneous matters, it will be at the end of the initial
កិច្ចបន្ត
hearing.
បញ្ជីនេះត្រូវបានប្រគល់ទៅឲ្យភាគីជាលក្ខណៈសម្ងាត់បំផុត
The President, this list is provided to the parties on a strictly confidential basis.
It doesn't vote.
I have a point of order I would like to raise.
ខ្ញុំមានចំណុចមួយលោក
With regard to the agenda.
តើតើទៅនឹងប្រធានបទនឹងរបៀបវិរៈនៃអង្គសាវនកម្មនេះ
តើលោកត្រូវចំណាយពេលប្រមាណដើម្បី
The
លើក
President,
ឡើងបញ្ហានេះ
how much time will you need to make this short speech?
អញ្ជើញ
The President, you may proceed.
Thank you very much.
សូមអរគុណលោក
As my client explained, he's not very happy. I would like to explain why he's not very happy.
សូមបញ្យល់ថាហេតុអ្វីបានជាគាត់មិនសប្បាយចិត្ត
This is not an initial hearing.
មិនជាសាវនកម្មបឋមទេ
It may be in the case against Yang Sari, but not against, in the case against our client. As you know, we have raised several preliminary objections, and most importantly, our main objection was against the judicial investigation carried out by the investigating judges. That was so unfair and so harmful to the rights of our client, Nuon Chea, that we think, that we are of the opinion, and so is our client, that these proceedings should be terminated. We also asked for over 300 witnesses. Witnesses we think should be heard in public. Witnesses about the historical context of this trial, of these proceedings, of the conflict, and also witnesses on the judicial investigation. We wonder why we bothered. This trial chamber, Your Honours, have set an agenda for a 4-day hearing where none of our objections and none of our witnesses will be discussed. Although the rules of this court state that these objections and all of our witnesses should be discussed in this very hearing. Our client sincerely believes that he has the right to raise preliminary objections, and he believes he has the right to explain why these objections are so fundamental that they should be discussed before the beginning of the trial. And he believes that he should be allowed why all of his witnesses, he should be allowed to explain why all of his witnesses should be heard at trial. And crucially, our client, Nuon Chea, he believes that all of this discussion should be done in public, should be made in public, for the benefit of the Cambodian people. Why is our client Nuon Chea not given the opportunity to explain? Why is he not allowed to explain why the judicial investigation was so unfair, fundamentally unfair? The sole purpose of the judicial investigation was to collect evidence against our client and to ignore all the evidence that could put his role during the Khmer Rouge year in a different, more positive light. Why can he not explain? Why can he not say so? Why are we not allowed to tell this court today to explain to the people of Cambodia that the government has from the very beginning obstructed the investigation in the case against our client, like they are now doing in cases 3 and 4. We sympathize with the prosecutor and fully understand his current frustrations about case 3 and 4. We filed over 26 to be precise, requests for investigative action, and the investigating judges largely ignored them. They didn't do anything with them. Why were the terrible American bombings of Cambodia, why were they not investigated? And their lasting impact on the people in this country. And why not the dubious role played by Vietnam, the Vietnamese in this country, in Cambodia, before, during and after the Khmer Rouge years? Is this court trying to bury history? And why were this indispensable insider witnesses? 7 witnesses, why were they not heard by the investigating judges? It is not because we didn't ask for them. It is not because there was no reasons to hear them. These insider witnesses were all important key figures in the Eastern Zone, where, according to the prosecutor, terrible crimes took place. These insider witnesses, these important key witnesses, were not heard because the government of this country failed to cooperate. They simply ignored court orders. The way the initial investigation unfolded shows that this government still fails to understand the importance, the crucial importance, the meaning of an independent judiciary. Government should not tell judges what to do. And there is strong evidence that that is exactly what happened in the investigation, the judicial investigation against Nuon Chea. And that is what our client would have liked to explain today and in the coming days. As said, that judicial investigation was so unfair that the case against Nuon Chea should be stopped and should not go to trial. The trial is like building a house. I've almost finished. It needs solid foundations, solid judicial investigation. Without a proper foundation, the trial will sooner or later collapse. This is a historic occasion, at least it should be. But it's not the first time that alleged leaders of the Khmer Rouge are put on trial. As you know, in 1997, Pol Pot and Ieng Sary, they were convicted for genocide after a trial completely orchestrated and controlled by the Vietnamese. Since 1979, very little seems to have changed. If this court is to avoid a show trial, it should start showing its teeth. Your Honour should not make the mistakes made in 1979, the mistakes made by the investigating judges. The decision to exclude Nuon Chea from this initial hearing is regrettable, but hopefully it's not too late. Not only Nuon Chea, our client, but also the people of Cambodia deserve a fair trial, a proper trial, aimed at establishing the truth and not simply at rubber stamping history books written in Vietnam or in America. We want a fundamental discussion on the judicial investigation, the foundations of a future trial, and a discussion on all of the witnesses to be heard at trial when it really matters. For over 3.5 years, the investigating judges carried out a secret investigation. Nobody knew what they were doing. Our client did not know, the public did not know. It is time for transparency, not for sealed envelopes. Our client cannot resign from these proceedings, like the international staff has done and is doing at the office of the investigating judges. But he cannot be forced to stay in this room today. He will leave and only come back when the trial chamber, this trial chamber, Your Honours, are willing to discuss his objections and all of his witnesses. If not this week, then at the next initial hearing. Our client does not longer want to honour these proceedings with his presence unless his objections and all of his witnesses, not just the ones in the envelope, but all of his witnesses are put on the agenda, as the rules of this court prescribe.
The President, the Chamber will not allow such interruption again. We shall now proceed with the agenda of the initial hearing. This list is provided to the parties on a strictly confidential basis and indicates the pseudonyms by which all witnesses, experts and civil parties contained on this list are to be identified in open session. This is pending ultimate decisions on whether or not each witness, expert or civil party on this list will be called or protective measures where required. Time has been allocated during the final day of the initial hearings for the parties to comment on this provisional list. The President, Nunchi, if you would like to speak, you may proceed. Nunchi, Mr. President, Your Honours, I'd like to request to leave the courtroom and I will prepare myself to return. If Your Honours will consider my request to be put for discussion before the general public in the open court. The President, the security guards, you are instructed to bring him back to the detention facility. The President, time has been allocated during the final day of the initial hearings for the parties to comment on this provisional list of witnesses, civil parties and experts. If the parties agree to refer only to these pseudonyms indicated for each witness, expert or civil party, when discussing this list, the Chamber considers that most segments of the initial hearing, including those pertaining to witnesses, civil parties and experts, may remain in open session. Would any party object to this or propose that the Chamber go into closed session during its final day when the provisional witness, civil party and expert list will be discussed? If you have, you can take the floor. The President, you may proceed. Counsel.
Mr. President, the Chamber is aware that we will not depose as civil party lawyers the list of civil parties, and we know that on Thursday we will have the opportunity to speak on this subject, but we think it would be appropriate that we be allowed to furnish some practical explanations today for reasons of good faith, in respect of which we have not filed at this stage of the proceedings the list of civil parties. Would you allow me to explain in a few words these good faith reasons?
The President do not allow, because we already mentioned if needed the closed session will be conducted and open sessions will be used if all the parties agree that pseudonyms will be used for all the witnesses, experts and civil parties contained in the list already. If, depending on the view of the parties, and if when the chamber considers appropriate, closed sessions may be conducted. Where it deems appropriate.
Monsieur le Président,
Mr. President, I have understood that we have the opportunity of making submissions in closed session, but I want to refer to the decision of the pre-trial chamber issued on Friday. We now have 2,124 civil parties. There are 3,800 civil parties we have to defend. And that is why we have not yet filed any list. And I thought I should be allowed to furnish some explanations because we need your clarifications as to the procedure we will use with a view to choosing specifically civil parties who will appear before the court to explain themselves. It would appear that the trial cannot proceed without the civil parties being given an opportunity to choose their lawyers and in consultation with their lawyers and to be able to come and explain before the court. We have not submitted a list so far. We are in a position to justify our list, citing proper jurisprudence, and I would like to explain the situation to you and to request your clarifications on how these lists should be drawn up, because we definitely intend to draw up such lists.
The President, any other parties who would like to give their opinions on the proposed list that I just mentioned?
Good morning, Mr. President. Good morning, Your Honors. Good morning to everyone in and around the courtroom. It would be our submission that there be a general discussion in public as far as who can and who cannot appear before this court in public. And then, with respect to specific individuals, there could be closed hearings. But as far as the debate as to how one is chosen to go confidential or in closed session versus open session, I think that needs to be aired out in public without mentioning any names. This way, it's a transparent process, and everyone knows why certain evidence cannot be heard in open session. With respect to the specific witnesses, of course, that should be in closed session. Thank you.
The President, thank you, Counsel, for your suggestion. The Chamber have noted the suggestions by the councils. If there are no more opinions or suggestions, the Chamber will consider the suggestions when the time comes to discuss the list of witnesses, experts and civil parties. You may proceed. Good morning, Your Honors. Good morning, everyone. I am the defense counsel for Mr. Khieu Samphan, the former head of state. I noticed as the President just spoke, on Thursday we will discuss the list In public, I'd like to suggest that on Thursday we shall discuss it in public or in closed session, because my list of witnesses do not have the pseudonyms in the envelope that we received. So when Thursday comes, we shall discuss the list of my witnesses in closed session. Thank you, Mr. President. The President, thank you, Council.
Mr. President, I believe I have understood that consequently we will not be able to furnish explanations today. We'll do that on Thursday. We'll also obviously draw up the list of civil parties, and we believe that pursuant to Rule 80 base of the internal rules, we are the only party that will be able to proceed to reduce the list. So we'll propose a reduced list on the first 4 subjects to be dealt with at trial. We will not be able to explain why today. We will do that on Thursday.
The President, thank you for all the suggestions regarding the proceedings in deciding on the list of witnesses, civil parties and experts to be summoned to provide testimony on the 4 subjects during the substantive hearing, and whether it shall be conducted in public or in closed session. We have heard your opinions and suggestions. Although they are different in nature, and we have noticed all those suggestions, and we will consider these issues either on Thursday or on the last day of the hearing. In its tentative list of witnesses, civil parties and experts, the Chamber has indicated those it considers to be most relevant and probative of the facts at issue in the early trial segments. Over the course of trial, the Chamber will also consider calling other witnesses, experts, and civil parties, should it consider this necessary to comply with Rule 87(4) of the internal rules. The Chamber will also take into account those civil parties who are newly admitted following the recent pre-trial Chamber's decision ruling on their status. These new civil parties are now part of the consolidated group. Some may be considered for addition to the list of those who may be heard concerning the impact of the alleged crimes at a later stage of the trial. In view of the Chamber's obligation to ensure an expeditious and fair trial, however, the Chamber will not, as a rule, call witnesses, experts, and civil parties whose testimony, even if relevant, is likely to be repetitive of other evidence before the Chamber. As the evidence of a cumulative total of 1,054 witnesses, experts, and civil parties have been sought by the parties. The Chamber has previously indicated that it intends to hear the testimony at trial of substantially fewer persons than this total. Following oral argument on its provisional list, the Chamber expects to provide a definitive list of witnesses, civil parties, and experts for the early trial segment shortly after the initial hearing. Further information concerning proposed witnesses, civil parties, and experts who are considered by the Chamber to be instead relevant to later phases of the trial will be communicated to the parties at a later date. The Chamber is in receipt of a number of motions from the parties seeking clarification as to what, if any, contact is permitted between the parties and witnesses and experts in advance of their testimony at trial. A feature of the civil law system which governs proceedings before the ECCC is that the vast majority of witnesses and experts relevant to this trial have previously been heard before the co-investigating judges. All are accordingly witnesses who have already been subject to a judicial process, and if appearing before this chamber, do so as witnesses of the court. In a select number of cases, and where the chamber has doubts as to the internal consistency of these witnesses and experts' prior statements, or whether a witness or expert may recall features of them, the chamber may take steps to ascertain this. The party will in all cases be advised of the chamber's initiatives in this regard. Where proposals to hear new witnesses are accepted by the chamber, it will be for the chamber to ascertain whether testimony from these new witnesses or experts complied with Rule 87.4. This may also, in some cases, entail the chamber having direct contact with proposed witnesses or experts to ensure that valuable court time is not wasted in calling witnesses or experts whose testimony may not comply with Rule 87.4. The chamber had earlier advised the parties that, in due course, indications of documents considered relevant to the early trial segments would also soon be sought from them. The chamber requests the parties to indicate which documents and exhibits from their earlier document and exhibits list are considered to be relevant to these early trial segments no later than Friday, 22nd July 2011. These early indications will allow the interpretation and translation pool to ascertain the translation status of key documents and the chamber to identify pending difficulties as soon as possible. The chamber also provides early notification to the parties that it will shortly after this date set deadlines for the filing of written submissions outlining any admissibility challenges to those documents indicated as relevant to the first trial segments. The parties will now have an opportunity to raise any other points on which they seek clarification with respect to these provisional witnesses, civil parties and experts list, and the procedure to be followed in relation to it. If any party wishes to raise your point, then you may proceed starting from the co-prosecutors and then the lead co-lawyers.
The President, Mrs. Chia Liang, you may now proceed. Mrs. Chia Liang,
អ្វីដែលខាងប្រធា
Your
ន
Honours,
អង្គជំនុំ
the
ជម្រះសាលា
President,
ដំបូងបានលើកឡើងពាក់ព័ន្ធទៅនឹងសាក្សី
what
នៅ
the
ទី
chamber
នេះ
has already indicated
ជាទូទៅសហប្រញ្ញា
concerning
ឯកភាព
the
និងគោលដៅ
witnesses
ដែល
in general, the
ខាងអង្គជំនុំជម្រះសាលា
co-prosecutors
ដំបូង
have
មានបំណងចង់
fully
ធ្វើ
agreed with the
ប៉ុន្តែខ្ញុំ
intention
គ្រាន់តែមានបញ្
as
ហាតិចតួច
indicated
ពាក់ព័ន្ធ
by the
មិនទាន់មាន
chamber.
ភាពច្បាស់លាស់
However, we
ទៅ
still
លើ
have
បញ្ជី
some
សាក្សីដែលបានប្រគល់ឲ្យមក
points
ពី
that we
ទាំង
need
អស់
clarification
ក្នុងនោះរួមមាន
on,
ព្រះញ្ញានិងមេធាវី
including
ការ
the
ពារ
list
ក្តីទាំងអស់ដែរ
given to the
ខ្ញុំពិនិត្យ
parties.
មើលនៅក្នុង list ឈ្មោះទាំងអស់នេះ
Having
យើង
reviewed
គិត
the
ថា
lists,
ជាទូទៅយើងគិតថាជាបញ្ជីសាក្សីដែលសម្
I
ងាត់
can conclude that, of
ហើយ
course,
ក្នុង
there
ការលើក
are
ឡើង
the
អំពីម
confidential
ធ្យោបាយនៃ
lists.
ការធ្វើ
And
ខ្ញុំគិតថា
the-
ក្នុងឯកភាពដោយសារ
I
ស្នើសុំជាសាធារណៈចុះ
agree
ដោយសារយើងគិតថា
that
សវនកម្មរបស់យើងនេះ
hearings on these list of witnesses shall be made in public because it is, of course, for the interest of the public. However, during the final day, I fully agree that the witnesses shall be the names of the witnesses shall be dubbed with code names if they are to be discussed in the hearing.
ចំពោះសាក្សីមួយណាដែលយើងលើកយកមកពិភាក្សា
I would like to ask, for example, if any witness name is to be discussed in the public, that names must be coded with code number to conceal the identity of the witnesses. The President, thank you for your observation. The co-international prosecutor, you may proceed.
Yes, thank you, Mr. President. I obviously share all of the remarks made by my colleague, but I would like to make one further point, and that is this. You will recall that we filed quite recently with the Chamber our position on the testimony, the evidence of the 4 accused, should they choose to give evidence. So we would obviously like this particular order, proposed tentative list, order of witnesses, to be considered in the light of our position on evidence by the accused, and that we believe that all 4 accused should give evidence in this case before any of the other substantive evidence is heard. Thank you.
អ្នកនោះអាចនឹងផ្ដល់ទស្សនកម្មនៅក្នុងពេលធ្វើសវនកម្មលើអង្គសេចក្តីសូមអរគុណ
The President, thank you, Mr. International Co-Prosecutor. Counsel Pek Ong, you may now proceed. Could the court officer be instructed to make sure the counsel might get Counsel Pek Ong,
តាមបណ្ដឹងរដ្ឋវិនីសាក្សីហើយនិងអ្នកជំនាញនេះ
when it comes to the list of witnesses and experts, the co-lead lawyers do not have any objection to having the list be discussed in public, because the certain numbers of witnesses have already been coded with pseudonyms, in particular those who are confidential witnesses. The President, thank you, Counsel. International lead co-lawyers, you may now proceed.
Mr. President, I wish to reassure the bench that we intend to file the list of civil parties. I want to take this opportunity nonetheless to emphasize that we now have 3,800 civil parties and that our lists will depend on these new civil parties. I also wish to express to you that we are delighted with the decision of the pretrial chamber that has admitted new civil parties to these proceedings. This will not be an obstacle for us. This will simply provide a broadening of the foundation that the civil parties intend to contribute to this trial. As representatives of all civil parties, because there are groups that comprise this collective made up of individuals who have each suffered, we will be utterly careful and attentive, because these civil parties intend to preserve their role as parties to these proceedings, which must not be confused with the status of witness. And this will certainly be emphasized when we establish and address the first list of witnesses and make sure that this distinction is drawn. We will also be very careful during the trial that the civil parties are recognized during these proceedings and that they enjoy their full rights. We will file this list, a reduced list, on Thursday, and we will seek clarification from the chamber. We have already sought clarification on the issue of policy of democratic Cambodia, which will allow us to fine-tune our list. And we await those clarifications by duty, but I can reassure you that we will file a reduced list of civil parties by Thursday. Thank you.
The President, thank you, Council. Does any other party wish to add additional points to this? If not, then we may proceed. The Chamber has taken note of the points raised by the parties and will return to them during the final day of the initial hearing or subsequently.
កំណត់នៅការបរិច្ឆេទសម្រាប់ធ្វើការទាញហេតុផលដោយផ្ទាល់មាត់នៅក្នុង
The chamber has scheduled oral argument during the initial hearing in relation to those matters which it considers to fall within the scope of Internal Rule 89. The chamber has already indicated that some legal issues characterized as preliminary objections by the parties will be decided by the chamber on the basis of the written pleadings alone. The chamber has also already indicated that Q. Sompon's preliminary objection concerning the ECCC's personal jurisdiction over him requires a mixed assessment of law and fact. It will accordingly be decided at a later date. The chamber considers that early clarification of a number of other legal issues, whether included as part of the parties' preliminary objections, filings or raised subsequently in other filings, may nonetheless assist in the fair and expeditious conduct of the trial. The chamber refers in this regard to the following legal issues raised in the parties' filings: the ECCC's general jurisdiction over international crimes under the principle of legality, the application of joint criminal enterprise and superior responsibility as modes of liability, the application of forced marriage, rape within forced marriage, enforced disappearance, and forcible transfer as other inhumane acts, as well as imprisonment and torture as crimes against humanity. Whether the facts establishing the conduct of rape should be characterized as the crime against humanity of rape rather than the crime against humanity of other inhumane acts, and whether or not crimes against humanity before the ECCC require a link to armed conflict. The chamber considers that many of these matters, which were raised by the parties as part of their preliminary objection submissions, have already been adequately briefed. It is unlikely to seek further submissions in relation to these areas. In relation to legal issues raised more recently by the co-prosecutors, the trial chamber has since granted all defense teams an extension of time until Friday, the 22nd of July 2011 to respond to filings E95, E99, E100, and one further prosecution motion, E96. The prosecution may reply to these responses should it so choose within days of that date. After having received these additional filings and any other submissions that it may request, the Chamber will rule on these issues at a later date. Any hearings that may be required in this connection will take place at a date and time to be determined. In response to various motions challenging the fitness of 3 accused to stand trial, the Chamber appointed an expert geriatrician, Professor John Campbell, to assess these accused. Professor Campbell has since undertaken these assessments and submitted his reports back to the Chamber in relation to all accused. The Chamber forwarded Professor Campbell's report in relation to 2 accused to their defense teams on a strictly confidential basis on 13th of June 2011 in English and on 23rd of June 2011 in Khmer. Should these teams have any comment on or objection to make to the report, written submissions setting forth the basis of any objection should be filed before the Chamber no later than Friday, 8th of July 2011. The Chamber will on that date file these reports along with any objections received within this deadline confidentially on the case file. The other parties, should they wish to do so, may then respond to these reports and any objection lodged to them no later than Friday, the 15th of July 2011. Counsel, you may proceed.
Your Honours, I'm not sure whether this is the appropriate time to raise this objection, but we do object to the report of Dr. Campbell to be put on the confidential part of the case file. Do you want me to address this issue now?
The President, with regard to your observation, we believe that you may include it in during the time when you make your submission. The President continues. The expert's report in relation to the 3rd accused was issued on 23rd of June 2011 and communicated to the relevant defense team on a strictly confidential basis on the same day in English. Its Khmer translation will follow as soon as possible. Should this defense team have any comment on or objection to make to this report, written submissions setting forth the basis of any objection should be filed before the Chamber no later than Monday, 18th of July 2011. The Chamber will on this date file the report along with any objections received within this deadline, confidentially on the case file. The other parties, should they wish to do so, may then respond to the report and any objection lodged in relation to it no later than Monday the 25th of July 2011. Should the Chamber consider that additional hearings are required in relation to the fitness of any accused to stand trial, these hearings will be scheduled at a later date. Any such hearings are likely to occur in August 2011. The Chamber advises the parties that the courtroom holding cells, which contain a video link and direct phone line between each cell and the courtroom, are fully operational. Any of the accused may, at any time during this hearing, choose to participate in these proceedings via video link rather than appearing in person. Whereas an accused chooses to remain in court but requires a short break, for instance, to use the bathroom, he or she may at any time be escorted from the courtroom without seeking the leave of the chamber. The accused are also not required to stand when the chamber recesses or resumes its session. Do parties have any points to raise concerning this observation? Councillor Kanawas, you may now proceed.
Good morning again, Mr. President, and good morning, Your Honors. With respect to your observations concerning the recent filings, we appreciate the extension. We think it's a modest extension. It's not sufficient. We do think that the prosecution deliberately waited on these issues to file them at this point when they should have been raised earlier. Some of the matters are clearly beyond the time limit. If it had been the defense, you would either not have accepted the filing or directed the DSS not to pay us. Here, they have been accepted. And for instance, the JC in particular, if you look at the substance of it at the very end, what they're asking is another bite at the apple regarding JCE 3, when in fact this was a jurisdictional issue. They knew they were going to appeal it, and they waited until the very end. And so at this point in time, Mr. President, I would simply ask for the following, that the parties, including the defense, be directed as to a cutoff date as to when jurisdictional issues should be time barred. Because you have to look at the substance. We do feel that the prosecution has deliberately tried to sabotage this trial by suggesting in the JCE motion that even if you find JCE 3 to apply, that you should then go ahead and have amici, outsiders, come in to brief you on what the law should be. After all of these months, and this is clearly a tactic to either delay or obstruct. And I mention this on the record because we're always being accused of that. Now they do say, but we can proceed in any event. And I want to be clear on the record. We cannot proceed with the trial unless we know what the modes of liabilities are. I cannot defend, I will not know which questions to ask or not to ask. The prosecution had months and months and months to file this. I do not object to them filing. I believe that they should avail themselves as much as we do. But they have to do it within the time frame. And so please instruct the parties when the cutoff date is, because we're approaching the stage where we need to focus on the facts, get the witnesses, and begin this trial as quickly as possible. The people are waiting, and the defense is not obstructing. I believe it is the prosecution that is trying to deliberately impede the ability of the defense to carry on with their work. Thank you.
The President, thank you, Counsel. International Court Prosecutor, you may now proceed.
Thank you, Mr. President. First of all, let me emphasize to the court that we were perfectly entitled to file those recent motions to which Mr. Carnavas is referring. I take great exception to being accused of sabotaging this case. And I would like to say to the court and to Mr. Carnavas at the beginning of proceedings that these kinds of terms and references in civilized proceedings are inappropriate, and I will not accept them. I would simply ask the court to direct Mr. Carnavas to file his response in the time that has been given and to desist in future from making these kinds of comments, which I do not accept.
The President, we believe that it is an appropriate time to take the adjournment, so we will take a 20 minutes break and resuming at 20 to 11. The Grefche, all rise.